Before we begin, please note that this presentation provides general information for educational purposes only. It is not legal advice. Immigration law is complex and specific to your individual situation. You should always consult with a licensed and qualified U.S. immigration attorney for advice regarding your specific circumstances. Imagine for a second that you've done it. You've landed the dream job in Silicon Valley, the transfer to the New York office, or the perfect spot to open your business in Miami. You've sold your car, you've told your friends and family, you've even started looking at apartments online. Your entire life is packed into boxes, both literally and figuratively, waiting for that one final stamp of approval. And then the email arrives, the one you've been dreading. Application delayed, request for further evidence. Or worse, application denied. Your heart sinks. Panic sets in. How is this possible? You hired a top-tier lawyer, a brilliant solicitor from a respected firm in London. You paid them thousands of pounds. They were an expert in UK immigration, so surely they could handle a US visa, right? Wrong. And that single catastrophic assumption is why your American dream is now a bureaucratic nightmare. The truth is that brilliant UK solicitor likely made a tiny, almost invisible mistake. Maybe they used the wrong terminology, misinterpreted a single line of the U.S. Immigration and Nationality Act, or structured your supporting evidence based on British standards, not American ones. To them, it was a minor detail. To the U.S. Citizenship and Immigration Services officer reviewing your case, it was a giant red flag. This scenario isn't just a hypothetical horror story. It happens every single day. And it's the reason this video exists. Because the single most expensive mistake you can make when planning your move to the United States isn't choosing the wrong shipping company or underestimating the cost of living. It's hiring the wrong kind of lawyer. You see, the US and UK legal systems, especially in immigration, are not just different. They are two completely separate universes, operating on different principles with different rules and a different language of law. Hiring a UK lawyer for a US immigration case is like asking a world-class chef who specializes in French pastry to cook you a perfect, authentic bowl of Japanese ramen. They might be brilliant at what they do, but they don't have the right ingredients, the right training, or the right instincts for this specific, highly specialized task. Over the next few minutes, I'm going to pull back the curtain and show you exactly why you need a US licensed immigration attorney on your side from day one. We're not just talking about theory. We're going to break down the three critical, non-negotiable differences between US and UK legal practice that can absolutely make or break your visa application. Understanding these differences will not only save you from potentially devastating denials, but it will also save you thousands of dollars and months, if not years, of stress and uncertainty. This is the insider information that separates a smooth, successful move from a soul-crushing saga of delays and rejections. And the first, most fundamental difference we need to talk about is something most people never even consider, yet it's the very foundation of why your UK solicitor is at a massive disadvantage before they even start. It's the legal system itself. Not the laws on the books, but the philosophy, the culture, the very DNA of how law is practiced in each country. The United Kingdom operates primarily on a system of parliamentary sovereignty. What does that mean for immigration? It means the rules are largely set out by Parliament in detailed, codified regulations. Think of it like an incredibly complex but ultimately logical instruction manual. The UK Home Office has a set of boxes, and your solicitor's job is to meticulously gather the documents that tick every single one of those boxes. If you need 70 points for a visa, you demonstrate how you get 70 points. If the rule says you need a bank statement showing X amount of money for Y number of days, you provide that exact statement. It's a system that, for the most part, values precision, order, and adherence to a clear, established framework. A UK solicitor is trained to be a master of this framework. They are an expert architect, building your case brick by brick according to a very specific blueprint. Now take everything I just said and throw it in the trash, because that is not how the United States works. The United States legal system is a completely different beast. It's an adversarial system, born from a revolution, built on the idea of checks and balances, and deeply rooted in case law and precedent. For immigration, this means the rules are just the beginning of the story. They are the price of admission to the arena, not the key to victory. Your application isn't just a file to be reviewed. It's a case to be argued. The officer at United States Citizenship and Immigration Services, or USCIS, isn't just a clerk checking boxes. In their domain, they are judge, jury, and sometimes executioner. They are granted a staggering amount of discretionary power. This single concept, officer discretion, is the rock upon which countless perfect applications, prepared by brilliant UK solicitors, have been shattered. In the UK system, if you meet the criteria, there's a very high probability of approval. Discretion exists, but it's far more constrained. In the US, you can meet every single listed requirement for a visa on paper and still be denied. Why? Because the officer wasn't convinced. Because they felt something was off. Because your evidence, while technically correct, didn't tell a compelling enough story to satisfy their subjective standard. Let me put it another way. Imagine you hire the world's greatest Formula One driver, a genius at navigating the chicanes of Monaco and the high-speed straights of Silverstone. Now, you ask him to win the Daytona 500. He's still a world-class driver, right? He knows how to operate a vehicle at the limit. But he's in a different car on a different kind of track with different rules and a completely different racing philosophy. He's used to precision engineering and aerodynamic grip. Now he's in a heavyweight stock car, bump drafting at 200 miles an hour with 40 other cars an inch from his bumper. He's not prepared for the culture of the sport. He doesn't understand the nuance. He'll be lost. A UK solicitor, no matter how brilliant, is that Formula One driver. They are an expert in their own highly complex, rule-driven environment. But US immigration is NASCAR. Can be messy, it's often about aggression and strategy over pure technical perfection, and you have to know how the other drivers think. A US immigration attorney has spent their entire career on that Daytona oval. They know every crack in the pavement. They know which official is a stickler for details, and which one can be persuaded by a well-crafted narrative. They know that the goal isn't just to present the facts. The goal is to persuade. Let's look at a real-world example. Take the O1 visa for individuals with extraordinary ability. The regulations list criteria, like receipt of nationally or internationally recognized prizes or awards, or published material about the applicant in professional or major trade publications. A UK solicitor will look at this like a checklist. Okay, we have an award, we have 3 articles, and we have a letter of support. We've met the criteria. They will assemble a neat, organized package presenting these facts. A US attorney approaches it totally differently. They know the checklist is a lie. The real requirement isn't to meet 3 out of 8 criteria. The real requirement is to prove, in the subjective opinion of the adjudicating officer, that you are one of the small percentage who have risen to the very top of the field of endeavor. That is an incredibly high and vague standard. So the US attorney doesn't just submit the evidence. They build a narrative. They don't just include the article. They highlight the circulation of the magazine and explain why being featured in it is a major accomplishment in the field. They don't just submit the award certificate. They include information about the awarding body, the number of nominees, and the prestige of past winners to frame its importance. They don't just get a letter of support. They work with the recommender to craft a letter that uses specific, persuasive language that mirrors the legal standard, turning a simple endorsement into a powerful piece of evidence. They are essentially writing a legal brief, arguing your case from page 1. They are preemptively answering the questions and doubts they know are lurking in the officer's mind. This adversarial mindset extends everywhere. Let's talk about something that seems simple: a marriage-based green card. In the UK, the spouse visa process is heavily document-based. You provide the marriage certificate, financial evidence, proof of cohabitation. It's largely a paper review. In the US, the paperwork is just the first step. The main event is the Stokes interview, a high-stakes interrogation where you and your spouse can be separated and asked intensely personal questions designed to expose any inconsistency, any hint of fraud. They'll ask you what side of the bed your partner sleeps on, what color their toothbrush is, what you ate for dinner 3 nights ago. A UK solicitor has likely never prepared a client for that kind of psychological gauntlet. They don't have hundreds of client experiences to draw from about the specific tactics used by officers at the local field office. A US attorney has. They know the personality of that office. They know the trick questions. They will drill you and your spouse for hours, simulating the real thing, preparing you not just to answer correctly, but to project the confidence and authenticity of a genuine couple under immense pressure. They're not just your lawyer. They're your coach for the championship game. This fundamental difference in legal culture, the UK's rule-based, checklist-driven system versus the US's discretionary, adversarial system, is the root of the problem. Your UK solicitor is bringing a meticulously crafted blueprint to a fistfight. They are preparing you for a debate club when you're actually walking into a courtroom cross-examination. They don't have the muscle memory for it. It's not in their training, it's not in their daily practice, and it's not in their professional DNA. They are playing an away game on a field they don't recognize, with a rulebook they've only read about. And this puts your entire American dream in jeopardy before the application is even stamped and mailed. But this is only the beginning, because the difference in the system itself is amplified by the profound difference in the actual role the lawyer is expected to play. It's not just about what they know, it's about who they need to be for you. In the United Kingdom, the role of a lawyer, a solicitor, is often that of an expert navigator. The system, while complex, is largely prescriptive. It's a series of well-defined paths. Your solicitor is the ultimate guide. They have the map, they know every turn, every potential pitfall, and they guide you through the process with precision. Their job is to ensure you meet the criteria, tick the right boxes, and present your case in a way that aligns perfectly with the Home Office's explicit requirements. They are, in essence, a master of compliance. They are your guide on a difficult but clearly marked trail. In the United States, your immigration attorney is not a guide. They are a warrior. They are your advocate, your champion, your strategist in a system that is, by its very nature, adversarial. This is the single most important distinction, and it changes everything. The American system is not a checklist. It's a contest. From the moment you file your first piece of paper, you are not simply requesting a benefit. You are making an argument. You are building a case. And on the other side of that case is a government agency, be it U.S. Citizenship and Immigration Services, or a consular officer in an embassy, whose default position is skepticism. Their job isn't to help you succeed. It's to protect the integrity of the system, and that often translates to a mindset of prove it to me. Prove you qualify. Prove your intentions are genuine. Prove you are not a risk. A UK lawyer is trained to present facts. A U.S. attorney is trained to win arguments. They don't just assemble your documents. They build a fortress of evidence around your petition. They don't just fill out a form. They write a legal brief, a cover letter that preemptively counters every potential argument the government could make against you. They are not just navigating a path. They are clearing one, often through dense, hostile territory. This isn't an exaggeration for dramatic effect. It is the fundamental reality of practicing immigration law in the United States. Let's make this real. Imagine you're a British entrepreneur wanting to start a business in the US using an E2 investor visa. A fantastic route for many. Now let's see how two different legal mindsets might approach this. A UK-based solicitor applying their native framework would look at the E2 requirements: a substantial investment, a real and operating enterprise, and its capacity to generate more than marginal income. So they would diligently help you gather the proof. They'd get your bank statements showing the transfer of funds. They'd help you draft a solid business plan. They'd collect the articles of incorporation for your new U.S. company. They would assemble a neat, tidy, and factually accurate package that on paper meets every single requirement. It's a perfect submission for a system that values ticking boxes. And it would very likely get denied at the U.S. Embassy in London. Why? Because the U.S. attorney knows something the UK solicitor doesn't, not because they're smarter, but because they live and breathe the American adversarial system. The U.S. attorney knows the consular officer isn't just a box checker. That officer is a gatekeeper, and they are trained to be deeply skeptical. They've seen it all. They've seen people try to buy a visa with a flimsy, destined-to-fail business. So the U.S. attorney's approach is completely different. They aren't just proving you meet the minimums. They are trying to convince a deeply skeptical human being. They know the word substantial isn't a fixed number. It's relative to the type of business. So they'll commission a report or find industry data to argue why your $75,000 investment in a consulting firm is just as substantial as a $500,000 investment in a manufacturing plant. They don't just submit a business plan. They work with you to create a document that reads like a Wall Street prospectus, complete with 5-year cash flow projections, market analysis, and a detailed hiring plan for American workers. They don't just show that you transferred the money. They source every single pound, documenting its legal path from your UK account to the US business account, proving it's not borrowed from a suspicious source. They will include letters of intent from potential clients. They will include quotes from equipment suppliers. They will include a signed lease for your office space. They are building a narrative. The story they are telling the consular officer is not "my client meets the rules." My client is a serious, dedicated entrepreneur whose success will be a direct benefit to the United States economy, and it would be illogical for you to deny this visa. Every single piece of paper is a weapon in your arsenal, a piece of ammunition for the fight. The UK solicitor prepared a package. The US attorney prepared a case for trial. This adversarial mindset extends to a crucial concept that is paramount in US law: building a record. Every single form you submit, every piece of evidence you provide, every answer you give in an interview becomes a permanent part of your immigration record, forever. A US attorney is acutely aware that they are not just working on your current visa application. They are laying the foundation for your green card application 5 years from now, and your citizenship application 10 years from now. A small, seemingly innocent inconsistency on a tourist visa application you filled out yourself years ago can be unearthed by an officer and used to question your credibility during your green card interview. An explanation in your E2 visa package that was weak or poorly phrased can create massive roadblocks down the line. A US attorney understands this. They are playing chess, not checkers. They are thinking about how every move made today will affect the board in the future. They are meticulously building a clean, consistent, and defensible record for you. This long-term defensive strategy is simply not part of the DNA of a legal professional trained in a non-adversarial transactional system. They are trained to solve the problem at hand, to complete the current application. The US attorney is trained to protect you from problems that don't even exist yet. So when you're choosing a lawyer, you're not just choosing someone who knows the law. You're choosing your champion for a specific type of contest. You wouldn't hire the world's best cricket captain to manage a baseball team in the World Series. Both are masters of a bat and a ball, but the rules, the strategy, the very soul of the game are universes apart. The skills are not transferable. Your dream of moving to America is your personal World Series. You need a manager who doesn't just know the rules, but who has spent their entire career fighting and winning on that specific field, under those specific high-stakes conditions. But knowing the rules of the game is one thing. What's even more critical is knowing the referees and the unwritten rules they play by. Let's dive deep into that idea. In the United States immigration system, the law, the text written in the Immigration and Nationality Act, is just the starting point. It's the blueprint. But the house isn't built by the blueprint. It's built by construction workers. And in our analogy, those workers are the thousands of individual USCIS officers, consular officers, and immigration judges who interpret that blueprint every single day. Each one brings their own training, their own biases, their own interpretation, and the culture of their specific office to the table. This is the human element, and it is the single most unpredictable and dangerous variable in your entire immigration journey. A lawyer in the UK has no access to this. They can read the law online. They can download the forms. But they have never spent a Tuesday morning waiting in the lobby of the Jacob K. Javits Federal Building in New York City, observing which officers are tough on marriage interviews and which ones are more lenient. They haven't had a dozen cases in a row with the California Service Center, and noticed a sudden unannounced shift in how they scrutinize H-1B visa petitions. They haven't built a professional reputation over years of direct, in-person and written correspondence with the very people who hold your future in their hands. Think about it like this. Every USCIS field office, every service center, and every U.S. embassy or consulate abroad has its own microculture. It's an unwritten rulebook. The Miami field office might be notoriously strict on proof of income, requiring an almost overwhelming amount of financial documentation. Why? Because of the unique history and patterns of immigration in that region. A local Miami immigration attorney knows this instinctively. They don't just submit the required tax returns. They submit 6 months of bank statements, pay stubs, and a letter from the employer, preemptively answering the questions they know that specific office is going to ask. Meanwhile, an office in Seattle might be laser-focused on the legitimacy of the relationship timeline for marriage-based green cards. They've seen different patterns, so they scrutinize different things. A Seattle-based attorney knows to build a veritable fortress of evidence around the courtship period, text message logs, photos with date stamps, flight itineraries from when the couple was dating. They know the local soft spots and the local hot buttons. A UK solicitor, operating from a distance of 5,000 miles, sees only the universal form, the I-130, and the generic list of required evidence. They prepare a case for a generic non-existent USCIS, not for the very real, very particular, and very human office in Seattle that will actually decide the case. They are sending their client into a specific battle with a generic map. This local knowledge isn't just a minor advantage, it can be the entire ballgame. U.S. immigration attorneys, especially those who are members of AILA, the American Immigration Lawyers Association, are part of a massive interconnected network. They are constantly sharing real-time intelligence. They have internal listservs and forums that light up with alerts like, "Heads up, the Vermont Service Center is suddenly issuing RFEs, requests for evidence," on cases that don't include a detailed relationship narrative. Or the U.S. Embassy in London has a new consular officer who is really drilling down on the sponsor's ability to support the applicant long-term. This isn't information you can find on a government website. This is earned intelligence gathered from the front lines. It's the difference between knowing the official rules of the road and knowing that there's a pothole on a specific street that you need to swerve to avoid. A UK lawyer doesn't have access to this intel. They aren't on those listservs. They don't go to the local AILA chapter meetings. They are essentially flying blind. Let me tell you a story that illustrates this perfectly. It's about a couple, we'll call them Liam and Jessica. Liam was from Manchester, England. Jessica was from Austin, Texas. They met while she was studying abroad, had a whirlwind romance, and got married in the UK. They were madly in love and wanted to start their life together in Austin as quickly as possible. They were smart, educated people, and they hired a highly respected solicitor in Manchester to handle Liam's US green card application. This solicitor was a star in the world of UK immigration. He was meticulous, professional, and prepared what he believed to be an ironclad case. Every form was filled out to perfection. Every required document was attached. He prepped Liam for his interview at the US Embassy in London, coaching him to be honest and direct. Liam went to his interview feeling confident, but the consular officer was skeptical. The questions were pointed. "You only knew each other for 6 months before you got married? Why the rush? Why not just get a fiancé visa? Does your wife have a stable enough job in Austin? How can you be sure you'll find work in your field?" The questions kept coming, probing for weaknesses. Liam, being honest as he was coached, gave straightforward answers. The officer remained stone-faced. 2 weeks later, they received a denial. The reason cited was vague. Insufficient evidence to establish the bona fides of the marital relationship. They were devastated. Their plans were shattered. The UK solicitor was baffled. He had followed the law to the letter. He filed an appeal, which was also denied. A year of their life wasted. Finally, on the advice of a friend in the States, they contacted an immigration attorney based in Austin. The first thing the Austin attorney did was ask for the entire file they had submitted. After reviewing it for about 30 minutes, she sighed and said, "I see the problem." She explained that the US Embassy in London is one of the busiest and most scrutinized posts in the world. Because of the sheer volume, consular officers there are trained to be incredibly skeptical of whirlwind romance cases, especially when the couple marries abroad instead of using the standard K-1 fiancé visa process. "It's a silent internal red flag," she said. "Your UK solicitor prepared a technically perfect case, but he didn't prepare a persuasive case for the London Embassy. For a case like yours, you can't just meet the minimum requirements. You have to overwhelm them with proof. You have to build a story so compelling they can't possibly doubt it." For the next month, she worked with them to rebuild the entire petition from the ground up. She didn't just include the marriage certificate. She had them write detailed individual declarations about how they met, their first date, the moment they fell in love, their proposal story. She didn't just include a few photos. She had them assemble a 100-page album with captions, dates, and names, showing them with each other's friends and families. She had them get sworn affidavits from Jessica's parents, Liam's parents, their siblings, their best friends on both continents, all testifying to the authenticity of their relationship. She gathered flight stubs, hotel receipts, screenshots of years of text messages and video calls. She had Jessica's employer in Austin write a detailed letter not just confirming her salary, but her future prospects with the company. She built a mountain of evidence so high the consular officer couldn't see over it. Then she prepped Liam for the second interview. She didn't just tell him to be honest. She role-played the interview with him, asking him the exact type of skeptical questions he was likely to face. She taught him how to answer not just the question being asked, but the concern behind the question. When the officer asks, "Why the rush to get married?" the concern isn't about the timeline. It's about immigration fraud. The answer isn't because we were in love. The answer is because we were in love, and we knew we didn't want to spend another day apart. We explored the fiancé visa, but being married felt more genuine to our commitment. and we were prepared to provide any evidence necessary to prove our relationship is real. Liam went back to the embassy. He faced another tough officer, but this time he was ready. He was confident. He presented the new, overwhelming evidence. He answered the questions with poise and understanding, and his visa was approved on the spot. The law hadn't changed. The couple hadn't changed. The only thing that changed was hiring someone who didn't just know the rules of the game, but who intimately knew the referees at that specific embassy, and the unwritten rules they play by. That is a home field advantage you simply cannot afford to give up. Let's break down what that home field advantage actually looks like on the ground, because it's not just some abstract concept. It's the difference between a dream realized and a nightmare of endless paperwork and heartbreaking denials. Imagine two chefs. One is a master of French cuisine. He knows every classic technique, every mother sauce, every delicate balance of flavor. The other is a master of Texas barbecue. He knows smoke, he knows time. He knows the alchemy of a dry rub on a brisket over 18 hours of low and slow heat. Now you ask the French chef to cook you a world-class, competition-winning Texas brisket. Can he do it? Maybe. He's a brilliant chef. He can read the recipe. He understands the principles of cooking. But he doesn't have the instinct. He doesn't have the thousands of hours of lived experience, the feel for the wood, the smell of the air, the deep-seated cultural understanding of what makes that specific dish not just good but authentic. He's translating his knowledge. The barbecue pitmaster isn't translating anything. It's his native tongue. Your UK solicitor, no matter how brilliant, is the French chef being asked to cook Texas brisket. And US immigration law, especially as it's practiced at a US embassy, is the most particular, stubborn, and unforgiving slab of brisket you will ever encounter. The core of the problem is this. The United States and the United Kingdom, despite sharing a common law tradition, have evolved dramatically different legal cultures, especially in the administrative and bureaucratic realms. The UK system, to generalize, often operates on a foundation of reasonableness. There's an inherent sense of, let's look at the situation and do what makes sense. There's a level of discretion and a reliance on principles that a UK-trained lawyer intuitively understands and navigates. Their entire career has been spent in a system where you present a logical, well-reasoned case, and you expect a logical, well-reasoned outcome. The US immigration system does not work that way. It is not a system of reasonableness. It is a system of brutal, hyper-specific, and often seemingly arbitrary regulation. It is a labyrinth built of statutes passed by Congress, interpreted by voluminous regulations from the Code of Federal Regulations, which are then further interpreted by policy memos from the State Department, and then reinterpreted by the internal, ever-changing guidance within the Foreign Affairs Manual, and finally, subjected to the individual discretion of a consular officer, who might have had a bad morning. It is a teetering Jenga tower of rules, and a U.S. immigration lawyer's job is to know precisely which blocks you can pull without toppling the whole structure. A UK lawyer sees the tower and thinks, well, it's a tower, it's mostly stable. A US lawyer knows that the third block from the bottom on the left side is cracked, and the whole thing is leaning 2 degrees to the north on rainy Tuesdays. This is where the lost in translation disaster happens. Let's take a real-world example I've seen play out dozens of times, the B2 Treaty Investor Visa. This is a popular route for UK citizens who want to start or buy a business in the States. On paper, the requirements seem straightforward. You have to invest a substantial amount of capital in a real, operating US enterprise that is not marginal. A UK solicitor looks at this and says, right, let's get a solid business plan, show you've got £100,000 in the bank, write a compelling cover letter, and we're good to go. They prepare a beautiful application package. It has market research, 5-year profit and loss projections, and a curriculum vitae that would make a CEO blush. It's a package designed to convince a reasonable person that this is a viable business and a serious applicant. And then it gets denied. Why? Because the consular officer at the US Embassy in London wasn't looking for a reasonable business plan. They were looking for specific evidence to satisfy hyper-technical, internal definitions of those key terms. Let's take the word substantial. To a UK lawyer, £100,000 for a new consulting firm is clearly substantial. But the US lawyer who specializes in the London Embassy knows that for that specific post for that type of business, the unwritten rule of thumb might be closer to $150,000, and more importantly, they want to see that money spent. Not sitting in a bank account. Spent. They want to see it irrevocably committed. This is the concept of the investment being at risk. The UK lawyer's client, following sensible advice, has kept the bulk of their capital liquid, ready to deploy once the visa is approved. It's the logical, prudent business decision. Nobody in their right mind spends their life savings before they know if they can legally operate the business. But the US consular officer sees that liquid cash and their brain flashes a huge red light. Not at risk. The US lawyer knows this. They would have told the client to do something that feels terrifying and insane. Before we even apply, I need you to form the US company. You need to wire the full amount into the US company's bank account. Then you need to sign a 1-year commercial lease for an office. You need to buy your computers, your desks, your software licenses. You need to spend $50,000, $60,000, $70,000 before we even walk in that embassy. This is the home field advantage. It's not just knowing the law. It's knowing the application of the law in that specific building. It's knowing the local legal culture. The culture of US immigration is fundamentally skeptical. The default position of the US government for anyone applying for a non-immigrant visa is that you are an intending immigrant until you prove otherwise. The burden of proof is 100% on you. A UK lawyer prepares a case to demonstrate merit. A US lawyer prepares a case to dismantle every possible reason for denial, preemptively. They aren't just building an argument. They are building a fortress around your application. They are playing defense against a system that is designed to say, no. Let's go back to our E2 applicant. The UK prepared application gets a denial with a vague, soul-crushing reason. Applicant failed to demonstrate the investment was substantial and/or that the enterprise was not marginal. The UK solicitor is flabbergasted. But it was a brilliant business plan. The projections were solid. They don't understand that the consular officer probably spent less than 3 minutes looking at the business plan. The officer was looking for receipts, for signed contracts, for concrete, tangible proof that the applicant had already jumped off the cliff and there was no going back. The US lawyer understands the psychology. They know the consular officer is a gatekeeper whose primary job is to prevent fraud and protect the integrity of the system. So they don't just provide evidence, they curate an entire narrative of irreversible commitment. They front-load the risk. They make it so the officer can look at the file and tick their internal boxes. Investment at risk? Check. Substantial? Check. Real and operating? Check. It's about transforming your application from a proposal into a report on an established fact. This isn't just a different technique. It's a completely different philosophy. It's the difference between asking for permission and demonstrating an undeniable reality. And that philosophy is born from decades of experience working within the unique, often illogical, and deeply adversarial culture of American bureaucracy. A brilliant UK lawyer is an expert in their own legal culture. But when they represent you for a US visa, they are an immigrant too, trying to navigate a foreign system whose unwritten rules and cultural assumptions can turn a winning case into a devastating loss. Let me tell you a story. It's a story I've seen play out in 100 different ways, with 100 different clients who came to me after it was already too late. It's the story of a brilliant software architect from Manchester we'll call David. David wasn't just good. He was a prodigy. He'd built a revolutionary new platform for logistical management that was being courted by a major tech firm in Silicon Valley. The offer was life-changing. The visa he needed was the A1, the so-called genius visa, for individuals with extraordinary ability. Naturally, David did what any sensible person would do. He hired a top-tier immigration solicitor in London. This solicitor was a Queen's Counsel, a big shot, the kind of lawyer who had represented multinational corporations and even members of parliament. He was, by every British standard, the best. And he looked at David's case and said with complete confidence, "This is a slam dunk. Your qualifications are impeccable." So they got to work. The solicitor, let's call him Mr. Abernathy, prepared the petition with meticulous British precision. He gathered David's university degrees, his employment records, and a list of the industry awards he had won. He included printouts of the articles written about David's company in respected UK trade journals. The final package was thick, perfectly organized, and factually unimpeachable. Mr. Abernathy was proud of it. It was a testament to logic and order. He told David, "The Americans are bureaucrats, but they respect evidence. And the evidence here is overwhelming." And then the denial came. It wasn't just a denial. It was a brutal, dismissive rejection from United States Citizenship and Immigration Services, or USCIS. The letter basically said they saw no evidence that David was one of the small percentage who has risen to the very top of the field. David was devastated. Mr. Abernathy was incandescent with rage. He was sputtering on the phone. "It's preposterous. It's illogical. Did they not read the file? We provided everything on their checklist." And right there, in that one sentence, was the entire problem. We provided everything on their checklist. You see, Mr. Abernathy, for all his brilliance in the UK legal world, made a classic and catastrophic cultural error. He thought the US immigration system was a logical box-ticking exercise. He believed that if you provided A, B, and C, the government was obligated to give you D. He approached it like a math problem. A US immigration lawyer knows it's not a math problem. It's a sales pitch. When David's file finally landed on my desk for a second opinion, I knew what I was going to see before I even opened it. And I was right. The application wasn't wrong, it was just quiet. It was polite. It was British. The personal statement, which Mr. Abernathy had helped David draft, was full of classic British understatement. Phrases like, "I was fortunate enough to be recognized by my peers," and "our team had a modicum of success in the market." To a USCIS officer in Nebraska, a modicum of success doesn't sound like humility. It sounds like you barely made a profit. Fortunate enough to be recognized doesn't sound like you're a leader in your field. Sounds like you won a raffle. The list of awards was just that, a list. There was no context. A US lawyer would have known that you don't just list the UK Tech Innovator of the Year award. You submit sworn affidavits from the judges of that award explaining why David's work was so groundbreaking it blew every other competitor out of the water. You include the press release, the photos of him accepting the award, and highlighted articles showing how the win shook up the industry. You don't just say he won. You prove that the award matters, and that his winning it was a major event. The articles from the trade journals? Mr. Abernathy had just included the printouts. A US lawyer knows the officer isn't going to read a dozen dense, 8-page articles. You get the authors of those articles, or other leading journalists in the field, to write letters summarizing the significance of David's work. You highlight in bright yellow the key quotes that call him a visionary, or a once-in-a-generation talent. You spoon-feed the conclusion to the officer. You make it impossible for them to miss the point. The US lawyer's job isn't just to present evidence. It's to build a narrative. It's to craft a compelling, aggressive, and unapologetic argument for why you are not just qualified but exceptional. It's about understanding that the person reviewing your file has a stack of 100 others on their desk and has about 15 minutes to make a decision about your entire future. You don't have time for subtlety. Mr. Abernathy was operating under the assumption that the government officer is a neutral, diligent arbiter who will carefully weigh all the evidence. A US lawyer operates under the assumption that the officer is a skeptical, overworked, and time-pressed gatekeeper whose default answer is no. Your job is to make it easier for them to say yes than no. You have to overwhelm them with such a powerful, well-packaged, and persuasive case that a denial would be more work than an approval. This is the cultural chasm. The British legal tradition, born from a system of barristers and solicitors, often values dispassionate reason and deference to the system. The American legal tradition is an adversarial one. It's a battle. From the very beginning, a US lawyer is trained to be a zealous advocate, to push the boundaries, to argue, to persuade, to fight for their client. That ethos is baked into every single thing they do, including filing a stack of papers for a visa. What Mr. Abernathy filed was a collection of facts. What a US lawyer would have filed is an argument, a closing statement to a jury of one. And this difference in approach goes even deeper when you get to the consulate interview stage. A UK solicitor might advise their client to simply be truthful and answer the questions asked. Don't volunteer information. Be reserved. Be professional. In the context of a US consular interview, this can be a death sentence. A US lawyer will prep you for that interview like you're preparing for a presidential debate. We'll do mock interviews. We'll drill you on how to answer the tough questions, how to project confidence, and how to proactively address any potential weaknesses in your case before the officer even thinks to ask. We'll teach you how to tell your story in a compelling 30-second soundbite. Because we know that the consular officer isn't just evaluating your paperwork. They're evaluating you. They are making a gut-level decision about your credibility, your intent, and your character. David's case wasn't lost because of a legal technicality. It was lost in translation. Not from English to English, but from one legal and cultural mindset to another. His London solicitor was an expert navigator of the British system, a system he understood instinctively. But when he stepped into the American arena, he was an immigrant too. He was trying to play chess on a football field, following all the right rules for the wrong game. The cost of that mistake wasn't just his legal fee. It was David's dream. So what was the fatal flaw in David's case? What was the one detail that unraveled a lifetime of work? It wasn't some dramatic courtroom blunder. It was quieter, more insidious. It was a single misunderstood form. The UK lawyer, accustomed to the British system's emphasis on the overarching business plan and the founder's credibility, had treated the source of funds documentation as a secondary element. He provided bank statements and a letter from David's accountant, which would have been more than enough to satisfy the UK Home Office. But for the USE2 investor visa, the paper trail for the source of funds isn't just a detail. It is the entire foundation of the case. The US government wants to see the unabridged, excruciatingly detailed story of every single dollar. Where was it born? How did it travel? They want to trace its lineage back, sometimes for years, ensuring it's completely legitimate and not just a loan designed to temporarily inflate an account for the visa application. David's UK lawyer had documented the existence of the money. A US immigration lawyer would have documented its biography. He would have known that the US adjudicator needed to see not just the final balance, but the wire transfers, the dividend statements from David's UK company, the sale of personal assets, the corresponding tax returns for each of those transactions, a complete, unbroken chain of custody. The application David's lawyer submitted was like a beautiful, expertly crafted house built on a foundation of sand. When the first wave of scrutiny hit from the US consulate, the whole thing collapsed. The denial wasn't a maybe. It was a swift, brutal, and final no. And this is where we get to the heart of the matter. This isn't about one lawyer being better than another. It's about two legal universes that operate under different laws of physics. The United Kingdom's immigration system, while complex, is largely governed by a set of immigration rules laid out by Parliament and interpreted through extensive Home Office guidance. It's a system that, while strict, often allows for a degree of holistic review. An officer might look at the totality of the circumstances. The United States immigration system does not work that way. At all. It is a completely different beast, born from a different legal philosophy. American immigration law is governed primarily by the Immigration and Nationality Act, or the INA. This isn't a set of guidelines. It's a colossal, intricate, and often unforgiving piece of federal legislation. Think of it less like a rulebook and more like a massive, complex piece of computer code. If you miss a single semicolon, the entire program fails to compile. There is no good faith exception. There is no, "Oh, I see what you were trying to do." You either meet the exact letter of the statute, as interpreted by thousands of precedential court cases and agency memos, or you don't. Period. A UK lawyer is trained to build a persuasive narrative. A US lawyer is trained to build an unassailable fortress of evidence that satisfies a brutally literal statute. They know which specific words and phrases, which terms of art, are required to trigger an approval. This brings us to the second chasm, the language itself. Even when the words are the same, they mean profoundly different things. Let's take the concept of extraordinary ability. In the UK, the global talent visa is for a leader or potential leader in their field. The evidence required is substantial, but the definition feels intuitive. In the US, the O1 visa for individuals with extraordinary ability sounds similar. Right? Wrong. The term extraordinary ability is a legal term with a definition so specific and so narrowly interpreted it bears little resemblance to the common English phrase. To qualify, you can't just be a leader. You must prove you have sustained national or international acclaim and are one of the small percentage who have risen to the very top of the field. How do you prove that? By meeting at least 3 out of 10 hyperspecific criteria. Things like receipt of nationally or internationally recognized prizes or awards for excellence. A UK lawyer might see this and think, "Great, my client won the British Startup of the Year award." A seasoned US lawyer's first question would be, who gave the award? Was the judging panel national? Is it a recognized award outside of the UK? How many people applied? Was it covered by the BBC or just a local trade journal? They know the USS officer adjudicating the case in a service center in Vermont has never heard of that award, and will give it 0 weight unless you provide mountains of evidence proving its prestige according to their unwritten standards. Another criterion is published material about the applicant in professional or major trade publications or other major media. A UK lawyer might proudly submit an article about their client in The Guardian. A US lawyer knows that's just the start. They'll ask, "What's The Guardian's circulation number in the US? Was it a passing mention or a feature article? Was it about your client specifically? Or their company?" They know they need to build a case within the case for why this piece of evidence matters to a skeptical American bureaucrat. It's the difference between speaking English and speaking American legal English. They sound the same to the untrained ear, but the nuance can be the difference between a new life and a closed door. This difference in approach extends to the very culture of the legal practice. In the UK, there's often a more direct, sometimes even collaborative dialogue with the Home Office. In the US, your application is fired into a vast, anonymous bureaucracy. You will likely never speak to the person deciding your fate. Your entire life, your entire career, your entire dream is reduced to a stack of papers in a file known only by a 13-digit receipt number. That file is your only advocate. It has to speak for itself with no room for ambiguity. A US immigration lawyer's job isn't just to be a legal expert, it's to be a translator and a strategist. They translate your foreign accomplishments into the rigid language of the INA. They strategize how to package your life story to fit perfectly into the narrow boxes that USCIS provides. David's UK lawyer sent them a compelling story. But the US consulate wasn't looking for a story. They were looking for an audit trail. They were looking for evidence that ticked very specific, non-negotiable boxes. And because those boxes were left unchecked, the file was closed. For David, this realization was a slow-motion car crash. He saw the denial letter, with its cold, formal citations to sections of US federal law he'd never heard of. His UK lawyer was genuinely confused, defending the quality of the business plan, unable to grasp that the battle was lost on a completely different front. And in that moment, David understood. He hadn't just hired the wrong professional for the job. He had fundamentally misunderstood the nature of the challenge. He had prepared for a negotiation and walked into a forensic examination. The money he'd spent was gone. But worse, his timeline was obliterated, and now a visa denial was permanently attached to his name, a red flag that would make any future attempt exponentially more difficult. He was back at square one, only this time square one was in the middle of a minefield. He now knew he couldn't navigate alone. His American dream was in critical condition, and the clock was ticking. The silence from the US government was no longer a source of anxiety. It had been replaced by the deafening roar of a definitive, soul-crushing no. That denial wasn't just a piece of paper. It was a verdict on his competence, a judgment on his dream. Every penny saved, every late night spent planning, every hopeful conversation with his wife about their future in California. It all felt like a colossal waste, a monument to his own naivety. The money paid to the UK lawyer was gone, a sunk cost of over £5,000 that now felt like he'd simply set it on fire. But the financial loss was a flesh wound compared to the deeper injury. The real cost was the time, the emotional capital, and the black mark now permanently attached to his name in the US immigration system. He and his wife, who had been his rock, his unwavering cheerleader, now had conversations laced with a tension they'd never known. The what-ifs became, why did you trust him? Why didn't we do more research? Why did you think it would be so simple? These weren't accusations, but they felt like it. They were the painful autopsies of a shared dream, and James had no answers. He felt like a failure, not just as an entrepreneur but as a husband. He had sold his wife on a vision of a better life, and instead, he had led them straight into a bureaucratic brick wall. The UK lawyer, when confronted, was a master of deflection. He'd sent a curt email, full of legal jargon, essentially blaming the unpredictability of the US consular process, and pointing to the fine print in his contract that absolved him of any responsibility for the outcome. He offered a discount on a future attempt, a hollow gesture that felt more like an insult than an olive branch. For weeks, James was adrift in a sea of despair. He'd go to his office in Manchester, stare at his computer screen and feel nothing. The ambition that had fueled him for years had been extinguished. He started researching other countries, Canada, Australia, but his heart wasn't in it. It was like trying to fall in love with someone else when you were still obsessed with your first love. The dream was America. It had always been America. To give up on it felt like giving up on a part of himself. One night, unable to sleep, he found himself deep in an online forum for US visa applicants. It was a digital graveyard of shattered dreams, filled with stories eerily similar to his own. People from all over the world, denied for reasons they didn't understand. often after using local legal help. But then, amidst the posts of frustration and defeat, he saw a comment that hit him like a lightning bolt. Someone from Germany wrote, "You wouldn't hire a German real estate agent to buy a house in Texas. Why would you hire a German lawyer for a US visa?" It was so simple, so blindingly obvious, that James felt a fresh wave of anger at his own foolishness. He had assumed law was law, a universal language of statutes and precedents. He failed to grasp that US immigration law isn't just a set of rules. It's an entire ecosystem, deeply intertwined with American culture, politics, and an unwritten code of bureaucratic procedure. His UK lawyer had been like a tourist with a phrasebook, able to ask for directions but completely incapable of understanding the local dialect, the slang, the cultural nuances that truly govern communication. He knew the words, but he didn't know the music. That was the turning point. The despair began to recede, replaced by a flicker of something else: determination. He wasn't just going to find a lawyer, he was going to find the right lawyer. This time his search was forensic. He ignored flashy websites and grand promises. He looked for attorneys who were members of AILA, the American Immigration Lawyers Association. He looked for specialists, not generalists, lawyers who lived and breathed E2 visas, who understood the specific demands of the US consulate in London. He read testimonials with a skeptic's eye, cross-referencing names and looking for patterns. He was no longer a naive optimist. He was a wounded veteran, and he was not going to be fooled again. After a week of relentless research, he scheduled a consultation with a law firm based in San Diego. The lawyer, a man named David, was everything his UK counterpart was not. The call didn't start with a demand for a credit card. It started with a question. "James, before we talk about visas and forms, tell me about your business. More importantly, tell me why you believe this business has to be in the United States." For the first time, James felt like he was talking to a business strategist who happened to be a lawyer, not the other way around. He spent 20 minutes explaining his vision, his market research, his passion for the industry. David listened, interjecting with sharp, insightful questions about his target demographic in California, his supply chain, and his 5-year growth plan. Then, David said something that fundamentally changed James's understanding of the entire process. "James, your first application failed not because you filled out a form incorrectly. It failed because you didn't tell a story. A U.S. consular officer isn't just a clerk checking boxes. They are a highly trained, deeply skeptical federal agent whose primary job is to protect U.S. borders. They review hundreds of applications a week. You have maybe 15 minutes to convince them of one thing: that you are a legitimate investor with a real business, and not someone just trying to find a backdoor into the country." He continued, "Your UK lawyer submitted a stack of paper. We need to submit a compelling narrative. Your business plan? It can't just be numbers and projections. It needs to be a story of opportunity, detailing a gap in the California market that only your British brand can fill. Your investment? We need to meticulously document the source of every single dollar, creating an unimpeachable audit trail that shows it's legitimate, at-risk capital. Your intent to depart? That single checkbox you mentioned? It's the most misunderstood part of the E2 visa. A UK lawyer sees it as a legal requirement. A US lawyer sees it as a psychological test. We don't just check the box. We build a case for it. We show your ties to the UK. Family, property, professional connections. Not as a reason you won't be committed to your US business, but as proof that you are a person of substance who respects international laws and agreements." Every word David said was a revelation. He was peeling back the layers of the bureaucracy and showing James the human element at its core. The skeptical, overworked consular officer who needed to be persuaded, not just satisfied. The UK lawyer had prepared a tax return. David was preparing for a court case, and the consular officer was the judge and jury. He explained the concept of consular non-reviewability, the terrifying legal doctrine that means a consular officer's decision is often final, with almost no path to appeal. This is why, he stressed, you have to get it overwhelmingly right the first time. The previous denial, David explained, had raised the bar. They weren't just applying anymore. They were overcoming a prior negative finding. The burden of proof was now significantly higher. But instead of feeling discouraged, James felt a surge of hope. It was the clarity he had been desperately missing. The fog of confusion had lifted, replaced by a clear, strategic path forward. David laid out a detailed, multi-month plan. It involved completely rewriting the business plan with a U.S. market focus, redocumenting the investment to meet stringent standards, and gathering new forms of evidence to prove his binding ties to the UK. It was going to be more work. It was going to cost more money. But for the first time since he received that denial letter, James believed his American dream was not dead. It had just been in the hands of the wrong doctor. Now finally, he had found a specialist. The first call with the new US-based law firm was a revelation. It wasn't an intake form, it was an interrogation. But it was the right kind of interrogation. They didn't just ask what he did. They asked why it mattered. They didn't ask for a list of his awards. They asked for the selection criteria for each award, the number of competitors, and the prestige of the judging panel. They weren't just collecting facts. They were hunting for a narrative. The UK lawyer had asked James to prove he was good at his job. This new lawyer, an American attorney who had spent 15 years practicing only US immigration law, was asking James to help her prove that his presence in the United States was an undeniable benefit to the nation itself. The entire frame of the conversation had shifted. The strategy she proposed was bold. It wasn't about simply reapplying. That would be like trying to fix a collapsed building with a fresh coat of paint. No, this required demolition and a brand new foundation. The plan was to file what's called a motion to reopen or reconsider. This is a specific legal tool in the US immigration system that essentially asks the government to take a second look, arguing that the initial decision was based on an error of fact or law. In this case, the US lawyer was preparing to argue that the previous filing was so deficient, so fundamentally misunderstood the legal standard, that it constituted an error that needed to be corrected. It was a high-risk, high-reward strategy. It required them to not only prove James's case from scratch, but also to implicitly demonstrate the failings of the previous attempt. The first step was a forensic autopsy of the denial letter. The US lawyer treated that document like a sacred text, dissecting every sentence, every phrase. She explained to James that USAS adjudicators are trained to use specific language. A phrase like "the evidence submitted is not persuasive" isn't a casual remark. It's a specific legal conclusion. She cross-referenced each reason for denial with the original evidence James's UK lawyer had submitted. What she found was a pattern. It wasn't that James lacked the qualifications. It was that the evidence was presented without context, without explanation, without a guiding hand to lead the adjudicator to the correct conclusion. The UK firm had essentially dumped a box of puzzle pieces on the government's desk and expected them to assemble the picture. The US lawyer's approach was the exact opposite. She was going to build them a masterpiece and hand it over, fully assembled and framed. She called her process evidence curation. For every single piece of evidence they submitted, there would be a cover page explaining what it was, why it was relevant, and which specific legal criterion it was meant to satisfy. The new petition wasn't going to be a stack of papers, it was going to be an argument. Let's get specific because this is the billion-dollar difference. Remember those articles about James in industry magazines? The UK lawyer had just submitted printouts of the web pages. The US lawyer did something else entirely. She had her team research the circulation numbers, the target audience, and the international prestige of each publication. She then included a one-page summary for each article, highlighting quotes that spoke to James's expertise and influence. She even found statements from industry experts about the importance of being featured in those specific journals. So instead of the adjudicator seeing a simple article, they saw a comprehensive analysis proving James was featured in major media, a key criterion for his visa category. The evidence didn't just exist, it was explained. Or consider the letters of recommendation. The UK lawyer had used a generic template, resulting in 5 letters that all sounded vaguely the same. The US lawyer threw them all out. She personally interviewed each person James wanted a letter from. She spent an hour on the phone with his former CEO, with a top academic in his field, with a major client. She explained the legal standard they needed to meet, and then worked with them to draft letters that were deeply personal, incredibly detailed, and packed with specific anecdotes and metrics that showcased James's unique and critical role. Each letter was a weapon, precision engineered to target a specific part of the legal test. One letter focused on his original contributions, another on his leadership, a third on his high salary in relation to others. Together, they formed an interlocking wall of support. And then there was the issue of his leading or critical role. The UK lawyer had submitted an organizational chart. The US lawyer called that Exhibit A in the Museum of Lazy Legal Work. For the new petition, she built a narrative. She gathered project plans, internal emails, and client testimonials that showed, not just told, how James had personally steered multi-million-dollar projects to success. She created a visual timeline of a key project, with call-out boxes at each stage detailing James's specific contribution and the successful outcome. She was painting a picture of an indispensable leader, not just a name in a box on a chart. The centerpiece of this entire effort was the petition letter. The original one from the UK firm was a mere 3 pages long. The new one, drafted by the US lawyer, was a 40-page legal brief. It had a table of contents. It had an index of 117 distinct exhibits. It began with an executive summary that laid out the entire argument, and then section by section, it walked the adjudicator through every single legal requirement for the visa. For each requirement, it would state the law, present the argument, and then systematically cite the overwhelming evidence they had curated. It was a masterclass in persuasion. It anticipated every possible question, every potential doubt, and neutralized it with a mountain of documented proof. It wasn't just a petition. It was a closing argument delivered before the trial had even begun. Throughout this grueling 3-month process, James was a partner, not a passenger. He was on daily calls with the legal team, digging up old emails, connecting them with key people from his past, and helping them understand the nuances of his industry. He felt empowered. He finally understood the strategy, the why behind every document request. The fog of confusion had been replaced by the clarity of purpose. This wasn't just about getting a visa anymore. It was about presenting the truth of his career in a way that was undeniable. Finally, the day came. The entire package, nearly 1,000 pages, was scanned and organized into a digital file. Every exhibit was labeled, every page was in order. The 40-page brief was the first document. It was a fortress of logic and evidence. As the lawyer shared her screen with James on a video call, he saw the final file, ready to be uploaded to the USCIS portal. It was more than a visa application. It was the culmination of his life's work, translated into the language of U.S. immigration law by a true expert. With a deep breath, she moved the cursor over the submit button. She clicked. The file uploaded. And then silence. The monumental effort was complete. The case had been made. Now all they could do was wait for the verdict. The silence that followed was the loudest, most terrifying sound they had ever heard. Every ping of a phone, every email notification, sent a jolt of adrenaline through their bodies. Days bled into weeks. The initial optimism, born from the sheer competence of their new lawyer, began to fray at the edges, worn down by the relentless, grinding anxiety of the unknown. Liam found himself replaying the conversation with the first UK-based lawyer. The breezy confidence, the casual dismissal of complexity. It's just a matter of showing the funds, really. A simple petition. Simple. The word was a cruel joke now. That simple petition had nearly cost them everything. It was a phantom limb, an ache for a mistake they had almost made, a path they had almost taken that led directly to a cliff. Priya, ever the pragmatist, tried to stay busy, throwing herself into her work. But in the quiet moments late at night, the doubt would creep in. Had they done enough? Was there some small detail, some overlooked document, that would unravel the entire painstakingly constructed case? They had placed their entire future, their shared dream of a life together in America, into a digital folder and sent it into the bureaucratic ether. They were completely powerless. The waiting wasn't just a pause, it was a trial. A test of their resolve, their patience, their faith in the system and in the expert they had finally trusted. They had done everything right, but in the world of immigration, doing everything right is never a guarantee of success. Just gives you a fighting chance. Then one Tuesday afternoon, an email landed in their lawyer's inbox. The subject line was an innocuous string of letters and numbers. Their USCIS case number. No congratulations. No notice of action. Just a sterile bureaucratic heading. Their lawyer saw it immediately. She took a moment, a single steadying breath before she called them. She knew the weight those few words carried. When Liam's phone rang, he saw her name and his heart hammered against his ribs. He put her on speakerphone. Priya rushed over, her face pale. "I have an update," the lawyer said, her voice calm and even, betraying none of the emotion she knew they were feeling. "I've just received the notification from USCIS regarding your case." The silence on the line was thick enough to cut with a knife. Liam could hear his own blood roaring in his ears. "They've reviewed the request for evidence response we submitted." Another pause. Felt like an eternity. This was it. The verdict. The culmination of months of stress, of hope and fear, of thousands of dollars and countless sleepless nights, all hanging on the next few words from this woman in an office thousands of miles away. "The petition," she said slowly, deliberately, "has been approved." For a second, the words didn't register. They were just sounds. Approved. Approved? And then the meaning crashed down on them like a tidal wave. Liam let out a sound that was half sob, half laugh. Priya sank into a chair, her hands covering her face as tears of pure, unadulterated relief streamed through her fingers. It was over. The fight was won. The door that had been slammed shut in their faces had been pried back open. They were going to America. Together. After the initial wave of emotion subsided, a new feeling began to settle in clarity. They finally truly understood. This outcome was not an accident. It wasn't luck. It was the direct result of a single critical decision: hiring a U.S. licensed immigration lawyer. Let's break down exactly why this made all the difference, because this is the lesson at the heart of their story, and it's the most important thing you need to understand. The first lawyer, the one in the UK, wasn't a bad person. He was simply the wrong tool for the job. He was a hammer trying to perform surgery. He saw a U.S. visa petition as an administrative task, a box-ticking exercise. He operated under the assumption that if you fill out the forms correctly and provide the requested documents, you get the visa. This is a fundamental and often fatal misunderstanding of the U.S. immigration system. USCIS isn't a simple processing center. It is an adjudicatory body. The officer reviewing your case isn't a clerk. They are a federal officer with immense discretionary power, trained to look for fraud, inconsistency, and reasons to deny. Your petition is not a request. It is an argument. You are making a legal case that you meet the stringent requirements for a benefit under the United States Immigration and Nationality Act. This is where the jurisdictional expertise becomes non-negotiable. A U.S. immigration lawyer is not just someone who knows the forms. They are a student of U.S. law. They have gone to a U.S. law school, passed a U.S. state bar exam, and are licensed to practice law in the United States. Their entire professional life is steeped in the nuances of the Code of Federal Regulations, the precedents set by federal court cases, and the internal policy memos of the Department of Homeland Security. When Priya and Liam's U.S. lawyer saw that RFE, she didn't just see a request for more financial documents. She saw a legal challenge to the very definition of income and assets under a specific subsection of U.S. law. She recognized the adjudicator's specific line of questioning because she had seen it before. She knew the relevant case law, cases like Matter of SMJ or Matter of Azumi, that had established legal precedent on how to evaluate complex financial situations for visa purposes. She could cite these cases in her response. The UK lawyer wouldn't have even known these cases existed. He was, through no fault of his own, legally blind to the actual problem. Think of it this way. If you were on trial in a Texas courtroom, would you hire a brilliant lawyer from France who only spoke French and had only studied French law? Of course not. It's absurd. The legal language is different, the procedures are different, the culture of the court is different. The U.S. immigration system is its own specialized courtroom. Your lawyer needs to be fluent in its language. The response that the U.S. lawyer drafted was not a letter. It was a legal brief. It made a structured, persuasive argument, supported by evidence and grounded in U.S. legal precedent. It anticipated the officer's potential counterarguments and systematically dismantled them before they could even be raised. It didn't just give the officer the documents they asked for. It gave them a legally sound reason to approve the case. It made saying yes the easiest, most logical, and most legally defensible option for that officer. That is the art and science of practicing U.S. immigration law. This isn't about geography. Your U.S. lawyer doesn't need to be in the city you're moving to. U.S. immigration law is federal law, meaning it's the same in California as it is in New York. Priya and Liam's lawyer was in a completely different state, yet she could represent them perfectly because she was licensed to practice U.S. law. The critical factor isn't where your lawyer is, but what law they are licensed and qualified to practice. A UK solicitor is an expert in UK law. An Australian barrister is an expert in Australian law. For a U.S. visa, you need an expert in U.S. law. Period. Your dream of moving to the United States, of starting a new life, building a family, seizing an opportunity, is one of the most significant undertakings of your life. It is not an administrative task you can outsource to the cheapest or most convenient option. It is a complex legal journey through a system designed to be skeptical. The stakes are too high to gamble on someone who is guessing. You are not just paying for forms to be filled out. You are paying for expertise, for strategy, for the peace of mind that comes from knowing the person navigating you through this minefield has walked the path 1,000 times before. You're paying for the knowledge that turns a devastating request for evidence from a dead end into a solvable problem. You're paying for the experience that turns a potential denial into an approval. Priya and Liam learned this lesson the hard way. Their journey took a detour through fear and uncertainty that could have been avoided, but they made the right choice in the end, and that choice changed everything. Their story is not just a cautionary tale. It's a blueprint for success. When you decide to embark on this journey, remember them. Remember that your future is not a form. It is a case to be won. And to win a U.S. case, you need a U.S. lawyer.